Hey, good morning, everyone. We'll be starting our methods subgroup meeting now. At this point, are there any things you wanted to say as we start this out, Olivia?
Nope. I sent out a bit of research yesterday that should be posted online for all of the groups to see. Including the forms that were discussed yesterday. Know that those can be Zoomed. They are used with only law enforcement and probation. And so please know that those are not to be distributed. They are locked, so they cannot be used, but they should not be distributed out of this group anyway. So you should have all of the information that I have. I'm still working on the 2005 research and pulling up the clips from 2005 legislative testimony, as well as 2014 and 2015 legislative testimony. And then also doing a spreadsheet for Stacy's request for all of the data requests that have come through and our responses to that. We will also be working with the judiciary to be sure that we are all on the same page about what we can and cannot find and pull.
Okay. Yes, so those forms, as Olivia noted, they've been emailed to you, the connection, but those forms won't be posted on the website for public access. We now do have a ready way of putting all the other documents, research attachments onto the web page. So by the end of the day, we should have any of those documents that have been requested and referenced in any of these meetings. There's one tab location for all of them, so you don't have to go to each meeting to find out which document was referenced. They'll all be in one centralized location on the web page. Again, we've gotten that system activated in place now, so I think from this point on, it'll be a pretty timely posting of both the recordings and any documents or attachments. So today we are.
Stacy, you had a question?
Yeah, I'm just looking at the forms, and for people who don't know what the forms are, who weren't on our last couple meetings, these are the forms that registrants need to fill out. Can I just ask a few questions about them quick?
Sure.
So I'm looking at them and they have names on them.
Made up.
They're made up.
Oh, okay.
Yeah.
Test record.
So
They're test records.
Okay. Just
or they're blue.
That. And then I guess my question is, why are these not available for the public?
Okay, they're not available to the public because they need to be filled out in the presence of law enforcement, with the exception of the verification form, which statute tells us the Bureau must mail it to their current primary address on file via the U.S. Mail Service, and the offender has 10 days to return it.
So under statute, they have to be filled out in the presence of law enforcement and probation, which is why they can't be distributed to the general public.
I guess I'm not seeing the connect though. Like, I mean, if I'm not required to register, I wouldn't use these. And even if they were public, they still need to be filled out in the presence of a law enforcement person. So,
So Stacy, history of kind of what's happened over the years, we've had probation agents send offenders changes of information via the U.S. mail or however they would give them to them. And then offenders would, photocopy this, keep them on hand. And then they have out-of-date versions of these forms that may not reflect what the statute would require of them. And so Therefore, those probation agents that had sent them out over the years, or even law enforcement, I suppose it could have been, the consequences have been that we get offenders that send in forms that are years and years old and not the most recent version. And I'm not really sure what the benefit of the public having access to a form if you're not required to register. What's the benefit of it?
Well, I think the benefit is if it's all statutory required information, there's really nothing that
So
seems
can
to
I-
me.
We are gonna keep these locked at least until the statute changes. That is what
Yeah.
the statute tells us to do. I don't necessarily know that we have the ability to change that until we are allowed to change that under statute. Because readily access of these forms gives folks access to forms that they should not be using and should not be filling out without the physical presence of a law enforcement officer or probation officer.
But so are these forms, but these forms are mailed to the
So,
person referring-
Stacy, okay, so maybe it's gonna help if I explain the forms that were received instead of making assumptions as to how they're received by the offenders. So the court notification form is that, I think it ends up being 3 pages because it's got the just acknowledgement that somebody is required to register and then the duty to register. So that's done with the court, at the courts. At the time of sentencing, it can be completed. It doesn't always get completed. Then there is then there's the registration form. Okay, that's that 8-page form that we looked at in the meeting yesterday, where it's got, the Tennyson morning, and then it asks a bunch of like demographic information followed by primary address, if they're homeless, a location of where they're going to be, followed by a work address, secondary address, work address, school address, and then that duty to and then some offense information for which they're going to be registering, and then that duty to register. So that's the registration form. That only gets completed when they have a new registration offense, not the DWI. Anytime they need to update their information, though, after they've completed that registration form, then it becomes the change of information form. And there's 2 versions of the change of information form. The preferred method is the online change of information, which is that 2-page form that we shared that has John D. test record on it. And then, and again, that is done. Law enforcement and probation have access to a system that they can complete that form, still the offender signs. Then the other one is the change of the physical form, the 5-page change of information form. Those 2 forms are used thereafter. Any changes need to be submitted after the registration form has been completed. And then the last form, then there was the homeless check-in. Offenders who are homeless, it's that 1-page form. It has to be done with law enforcement, not their probation agent. Has to be done with law enforcement, and that's required to be completed weekly if they are homeless, with the jurisdiction that they're homeless in. And then the last form that was included is that verification letter. That verification letter is required by statute, as I mentioned, that the Bureau must generate it and send it to the offender's current primary address. So that one is not, like that one you wouldn't leave available to anybody because that prints out specific, automated to the offender on the given anniversary date. So those were all the forms that we got. So maybe that kind of puts things into context a little bit more as to what's out there. And again, as it stands right now, the benefit of having forms available to the public, we don't see right now.
So I know, I understand that. So thank you for explaining what these all are. It's really helpful, and these are great to see. So I guess, this goes to Luis's presentation, excuse me, last week, just about the nature of the forms and the information that's needed to be provided. I guess from the public, I think that there's value to these forms not being available to the general public, but I've never seen these, and they're very interesting to me as an attorney. And so I guess I would respectfully disagree that there's no value to these being, able to be distributed I'm not suggesting they be put up on the BCA website for everyone to look at, but I guess I'm pushing back a little bit on this. These forms can't go anywhere. Because I just want to I want to understand what the rationale is, because if it's all statutorily driven, then it's just really the statute kind of put together in a form. But I want to understand, I guess I want to understand what the concern is besides this. I mean, these have sample watermarked pretty clearly, besides, people maybe filling out these forms if they would ever get in someone's hands, other than what they're sent. Is there another reason we wouldn't want the public to see this?
Yep. So for about 10 years, MSOP patients and clients have been reinventing the verification forms, reinventing registration forms, reinventing all of our forms and submitting them and resending them. And there has been extreme issues with folks doing that, to the point where it creates an immense amount of administrative and other burdens that are unnecessary when these are supposed to be controlled by law enforcement and probation only. So they were taken into a variety of different formats, changed, modified, and sent back. So we don't feel comfortable with that. That's going to be our stance with the distribution, because they can be changed, they can be modified, and they have been historically.
Jim.
I'm just trying to understand if as a private citizen were to make a data request of the BCA for just copies of their most recent form registration.
Yeah. Oh, general public, wait.
Can I just finish? If someone from the general public were to make a data request of the BCA for their most recent reforms or recent forms for registration, would that member of the public get those forms?
Yes.
Yes.
Okay.
We just sent them out to you all. So yes.
So once that person in the general public had those forms, they could distribute them as they saw fit.
Correct. And we would have the same administrative and other issues that we brought up.
Oh, okay. Thank you.
Okay, so if we go back to the design of what the methods group is doing, I think those processes for registering, filling out the forms is appropriate discussion here. The other area, which was a major area in the methods group, was also what ability registrants have to appeal or reduce their time periods for registration. And I think Angie went through quite a bit of that earlier on appeals of registration requirements, that judicial process or that court process to appeal the right to or the requirement to register. What hasn't been covered as much are those areas where you can seek relief from registration, not based on requirements, but due to lengthy period of adherence to the registration requirements. Any discussion on those issues or anything else that falls within the methods area? Well, this was the longest meeting last week. It's looking like it could be the shortest meeting this week.
No, we'll get going here.
No problem.
I'm interested in pulling up the minutes from last week or the notes to see what all the ruckus was last week. Well, I'd be interested in hearing from Representative O'Neill about just looking at the notes for, what your sense is on or what your view is on this, petition to remove petition for removal, we call it. I think that's how it's done in other states. What are your thoughts on that?
Well, that's interesting because I was just going to pose that question to the group. I mean, obviously, I'm not an expert in this, but I would wonder, what do you think it should take? What are some of the parameters that the courts should look at to determine whether or not someone has changed their course and they've taken positive action in their life and that they should be relieved from the responsibility of doing that? So I'd be open to the group to hear what are some of your ideas. We need to have concrete things, obviously, in pretty tight parameters so that it's, yes, it's judicial discretion, but they have to have a very solid guideline of what to follow.
Okay, Jim. Let's make sure you're. Are you able to? Okay, there you are.
There's a couple of things that there's a couple of things that I want to at least address. One is that I believe that there are people in this work group that might or do support having some kind of method where someone who's required to register could petition for relief. And then the question becomes, would they go to the judge? Would they go to a administrative panel, such as with the BCA, and then work out what those requirements are? I certainly, having attended these, and I haven't attended everyone, but everyone that I have attended, there appears to be a division on whether or not there is whether there's support for having any one of these, whether it's juveniles, whether it's same set of circumstance, whether or not there should be some amelioration of the those offenses that restart the period, and whether or not there should be a method to get off of the registry if you could demonstrate that, one, you were a probationary person who was required to register under the system, that you provided some kind of documentation that demonstrated, from either by way of a psychosexual or by way of other requirement, that you completed your probation and that you are not a danger, and that someone could then make a decision as to whether or not you would be required to register further. It seems to me that in the cases that type of case that I presented, that is at least would be a probationary person, possibly a juvenile registrant who has been on for some period of time that is not a risk and has some measurable way to demonstrate they're not a risk. What that could be, certainly could be, Representative O'Neill, subject for further discussion about it. But what I had certainly envisioned is that you have someone who's on the registry who has completed their probation, has, let's say, if it's a sex offense, completed sex offender treatment, and then has possibly another supporting documentation that says this person is not a risk or is a low risk versus other people in a similar circumstance. And whether or not that is presented to a judge, which we had understood that it's possible that the bench might not be interested in this, since I don't know that they would have jurisdiction or feel that they have jurisdiction about that, or it was presented to an administrative panel, since much of this registration is already administrative in its origin. And they certainly could make the recommendation or make the finding that the person should be required to be relieved from the obligation to register. That is the simple framework that I think we presented. I would be willing to bear down to find out more details, but the question that I have is to go up to the next level is whether or not this work group even supports that. And it's unclear to me that there is that support.
Stacy.
I'm looking at last meeting's notes, and it looks like you might have looked at the language that we came out of the CSE work group with the proposed ramp off language, which is all new language that we drafted. It was modeled, just for background, it was modeled after the expungement statute. Expungement is a policy that we want people who have made, positive improvements in their life to be able to move forward in a positive direction without, that black mark on their record anymore. And also, it's really important. The expungement statute is super important for people who are experiencing the collateral consequences of their conviction. I've represented folks on expungements, and they mean a lot to the people who actually, I've done it through the Volunteer Lawyers Network. And these are people who are usually struggling to find housing, and they need their record clean so that they can get subsidized housing. And it means a lot to them when they can achieve that expungement. So we modeled it after that, on the belief that people can do better, and that if they can show they're doing better, then we give them, we believe them, and we help them move forward. There was some discussion in the CSE working group about, well, how does, in terms of victims, like how do we deal with the victims? Should there be notice to victims? And just like the expungement statute, where there's notice to all the agencies that may have an interest in whether that person is entitled to an expungement, or maybe they have a different view of it, and they can come to the hearing, the expungement hearing, and oppose it. We're thinking about that too, because we want victims and survivors to feel like, that we're taking care of them, but that, that we also want, we want people to be able to, do better. So that was contemplated too. That feels really important. as an important part of it. So, and I'm with Jim. I would be interested. Our group is a little small today. I wonder if we're having work group or subgroup fatigue from yesterday's 2 sessions.
So, oh, I'm so sorry, Stacy, go ahead.
But anyways, I would love to just take the temperature of everyone here. If folks are like, no, 10 years is 10 years, or lifetime is lifetime, no need to discuss any further, then we can come up with other subjects to talk about and methods. However, if there is a feeling like, yeah, 10 years is a long time, and one of the issues is within that 10-year period, there's more opportunity. It seems to me that there's more opportunities to get things wrong on the registry than there are right. I'll just say, when I was a second-year associate working in a big firm in Chicago, I got this big, huge compliance program in the environmental group put on me. And the associate handing me the project said, there's more opportunities to mess this up than there are to get it right. Good luck. And that's, that was this complex regulatory program. And I feel like the registry, especially for people who are under-resourced, in all areas of resources, that the registry is, that we have good compliance rates, which was really great to hear yesterday. I was really glad to hear that. It seems like there's a lot of opportunities to have this re-trigger into another 10 years. And so if we could give an opportunity at year 5, for example, to say, hey, how are you doing at year 5? Because we know recidivism goes down the longer they're in the community, living offense-free and socialized. We know that recidivism goes down. The research supports that. So I'd be interested to take a temperature of the group.
So just a couple of things that we wanted to bring up as we're talking about expungements and notifying victims. That's something that the judicial branch and the BCA have worked on with regards to fiscal noting the expungement bills. We do not have victim data at all. And so the actual notification process for that would have to go through the prosecutors and the attorneys who were involved with that. So we just want to bring that up as you're talking about victim notification, that is going to have to be an outsourced program, project, IT, something like that. In terms of the BCA making determinations, we are not the judicial branch and do not feel comfortable making determinations on those things. We simply comply with the law as it is handed to us. So we would not feel comfortable assessing somebody. That is not something that we actively do or participate in. And so please just know that background as you continue to discuss this.
So I can launch a poll here that asks the questions. No change to 10-year registration, yes or no? No change to lifetime registration, yes or no? Did you want to see that with this group, or is that a poll you want to do somewhere else? I guess that question is to Stacy.
Oh yeah, at the CSC working group, we did polls all the time on Zoom, and it was really helpful. So I'd be willing if other people are willing, but there's hands up, so maybe there's some additional thoughts.
Okay, Renee. And you, at the end of the last meeting, you had said a starting point might be the criteria that Brian mentioned for getting a risk reduction. So it leads into that.
So if, as a collective group, we decide that, yes, indeed, we want to head down this road, I would suggest that, and I love your idea of a poll, I would suggest that it be a panel, a neutral panel of subject matter experts that know something about the cycle of offending and maybe has some knowledge base on risk assessment, that kind of thing. So I think we can, if we have the appetite for this, I think we can come up with some very concrete things that an individual would have to meet in order to look at the possibility of getting removed or relief from the registration. And I can throw lots of examples, but I think we should, and what that could look like. But I think we probably have to do a poll first before we get started on that criteria and that discussion.
Representative O'Neill.
Thanks. I think one thing we probably need to discuss and really understand before we get to this question is the collateral consequences of being on the POR versus just having a criminal history or assigned a level risk. Because in much of the conversation we had, I don't know that the collateral consequences were directly related to the POR. They definitely were directly related to a criminal history and a high level risk level assigned, a level 3 in particular. So I'm not comfortable voicing a vote either way until we really parse out where are these consequences coming from.
Karen. I think you're on mute. Okay.
I am, yes, thanks. Yeah, I guess felt like before we start taking a poll, I better provide the counter position in terms of whether this should be a branch matter. And of course, this is always an awkward question because I can't advocate that you don't draft, proposed legislation of that nature. It would add work for the courts, obviously, so that's a matter of concern. But we don't get to pick, if something becomes a judicial petition, we'll take the cases. I would note, however, that it is not unusual. I appreciate Olivia's concern that they're not a decision maker. Well, they're not now, but it's obviously not unusual for administrative agencies to be decision makers. DPS makes administrative decisions, DOR makes administrative decisions, and there are various ways those can be appealed, and statute differs in a number of ways. Some go straight to district court, some go straight to the Court of Appeals. So, as we think through whether this is something that that you want to add this ramp off of this petition process, I just think it's not a foregone conclusion that has to be a judicial branch issue at the outset. And if it does become one, I'm at least relieved to hear that some of the issues have been thought through in terms of who gets served, because when these new petition processes are created in law, they aren't always that specific. One example that comes to mind is the restoration of firearms rights. There's no guidance in statute as to who needs to be served, and that has been really difficult in terms of drafting court forms, court procedures. And so I'm not, again, at all advocating this become a court process. I think that's still a very open question as to where the decision is primarily made, what the route of appeal is. But if it is going to become a court process, then I think I'm going to have a lot of thoughts and suggestions in terms of what that process would look like so that it's workable.
Yeah, I think the same would occur for the BCA. We would need extremely specific guidance, checklists. We cannot be doing mental health assessments on people. We don't do that. That's not our expertise. We investigate, solve crimes, and maintain the registry. And so we share a lot of the same concerns that the courts have in needing. We do not want to be the ones assessing somebody. We don't have that skill set. That is not what we do.
Right, and I guess I should go back to your point about victim notice. Absolutely, the court and the BCA have always agreed about that. It's very rare that MNCIS has the victim information entered. It typically only happens if there's been a no contact order issued or a restitution order. If not, that's never data that makes it into the court system. So notice is indeed an issue. Yeah, I agree. And just, I guess, one comment about the assessments. I know nobody ever wants to talk about the money factor, but that is a constant question in the courts as well. Who pays for those evaluations? There's going to be some kind of a mental evaluation required. Is the defense required to just get that and then file it? Because if those questions come and everyone wants the judge to order an evaluation, the question is always, on whose dime? Because we only pay for very few branch. Yeah, so not to go too far off the rails, but I think that's where my head goes when we talk about this process is what are the criteria? How does it work? Where do you start? And who's responsible for all the various steps?
And just to go back to Renee's comment about that process for risk assessment relief, that is a administrative process within the Department of Corrections. It is appealable to the Office of Administrative Hearings. That happens in some cases, not most, but can be a complicated process, but it is fairly detailed statutorily on how that process is done. So Stacy.
Yeah, so I just wanted to respond to a couple things. Representative O'Neill, I think that Angie had sent out on the collateral consequences thing, collateral consequences of the registry versus the criminal conviction. So Angie sent out a table on September 30th at 8 p.m. that just listed all the collateral consequences to as I understood it, it was for the registry, is not for criminal convictions. Is that your understanding, Mark?
Yes.
So
No, so that is just related, those are just citations. So please know that that has anything to do with that statute as a whole. It does not have to do with solely the registry. So there's also community notification in that statute. There's a number of other items as well as access and use of data. So it cannot be considered solely for the registry.
The list is all those things that derive from the registry, including community notification. Without the registry, there would not be
Community notification is made by you independent of the registry.
It actually,
So it is 243.166 has a number.
so the Community Notification Act is based on the registry. Without the registry, there would be no community notification. It is contingent on that, so is directly a collateral consequence statutorily of the registry, as is all the other sections that Angie noted.
Mark, please don't mute me. That's
That was only to keep a little bit, to not have interruptions.
There are multiple things in that statute, and my concern is that we are not dividing that statute by subdivision when we talk about collateral consequences. So there's some that are related to the registry. There are some that were related to community notification, and I'm not sure how we divide up what impacts what based upon solely a statutory reference.
Okay. Representative O'Neill.
Okay, so let me ask this differently. There's a big difference between never being on the registry, never getting a level assessed, but having a criminal history, right? Because that happened. Well, I wouldn't say you're not on the registry, but just pretend like you're not on the registry. Versus assigning a risk, being on the registry and having those collateral consequences, and then coming off the registry. So what we're talking about is essentially an off-ramp off of the registry. And so what I'm trying to determine whether or not there's enough juice out of this squeeze is, what are they getting relief from? Because obviously much of what they've done lives forever on the internet. And are the collateral consequences like job, housing, all these other things directly related to the crime that they committed or the level they were assigned versus the predatory offender registry? So if we're going to have an off-ramp, I want to make sure that we're talking about the relief from the consequences of the off-ramp, and do they persist after, say if someone was on for 10 years and they were compliant and then they're off, what's the difference? What's the different picture we see the day before they're on it, or the day before when they're still on it, and the day after when they're not on it? What magically happens when they're no longer on the registry?
And then to answer that question, is all those listed statutory collateral consequences go away for those cases, including community notification. There are other non-statutory collateral consequences that probably won't go away. As you noted, the history of the internet, but all those things listed as collateral consequences in the statutory scheme would go away with elimination of the registration. So, Stacy.
Excuse me. So I understand better, Representative O'Neill, what you're driving at in terms of the collateral consequences. So thanks for that. That would require, I think, some analysis like this, to look at these and then to look at, like a felony, what other things track because you have a felony on your record, which is not expungible. I think that the collateral consequences is certainly a big one, that would be a driver for why we would want people to get off the registry. But then there's also, and this is for expungements too, people just want a clean record, and people don't want to have to register every year. And with the registry as it is now, because in that 10-year period, if you have a misstep at your whatever, you're reset for another 10 years. Or if you don't comply, it's a mandatory commit. So I think that we can look at collateral consequences, and those are really important. But I think in and of itself, being off the registry is a valid purpose and a valid objective, because people don't, if they've done well and they're doing all the right things, there should be some motivation and some reward for yep, we recognize that you're such a low risk, you're so low risk, that you should come off. The other thing I want to mirror what Renee said, which is looking at like the end of confinement review committee in terms of who sits on that committee. I totally agree that it would be a subject matter experts who are versed in assessing, how this person is doing. And it would seem to me that it would be an administrative panel, not the judiciary. I think the judiciary presents a whole host of problems in doing it there. But an administrative panel, much like the level setting for end of confinement review, it could be done there. And certainly the cost is an issue, but I guess my fear is, we've set up this registry. And if we say, oh, it's going to be too expensive to change the registry, let's just throw our hands up because it's too expensive. Well, we've set up a system that's, like we've got this system and now it's too expensive to change it. I know from a legislative standpoint, that's not going to be very compelling. Like, it's just easier to keep it. Let's not spend any money on these people. But to the extent that it may make, the public safer, because we're allowing integration, full integration, without the label, there's value there. So that's all I'll say.
Okay, Jim.
Representative O'Neill, I think to answer your question is taking low-risk people off of the registry eliminates, it's sort of, there's the collateral consequences, the potential criminal exposure for failing to register, particularly when an individual would be considered to be low risk. And that's my concern. There's just a number of ways that a person, particularly my clients who have failed or fallen and didn't register within the time requirements, and then found themselves facing more criminal liability, which generates more cases, that puts these more demand on the criminal justice services, criminal justice partners to respond to that by way of complaint and criminal process. And I just know that from what we have been, what we know, what we've been told, and particularly from corrections, there are a classification of cases where these folks present low risk. In fact, they would have probation officers that would say they shouldn't be on the registry any longer. And they would be certainly, that exposure to more criminal involvement, at least by way of failing to register, is eliminated.
Renee?
Yeah, I would agree with you. Keep in mind, it's just not the annual registration. When you look at that registration form in its entirety, every change that happens is something that they have to continue to update. So they do have a misstep in there, and that's been identified. Again, they get just wrapped right up into the system. That just creates more problems for them unintentionally when maybe they had a misstep. So I do, coming from the probation parole world, there are individuals that are low risk. There are individuals that are compliant. Again, I think we can identify under what circumstances, maybe what cases or situations, the offenses themselves, whatever that might be. I think we can come up with some concrete ideas. And again, I'll throw back in there that risk assessment, the risk to sexually reoffend, could also be a key component of that.
Senator Ingebrigtsen, you're on mute right now. Good.
Thank you. Representative O'Neill is, I think, on the right track here. Now we're bringing the legislative concept to this group, and I'm sitting here listening to this, and I really do appreciate all the different comments and the different concerns about this risk and that risk. But frankly, it can be very challenging, I think, when you go back to constituents and expect them to listen to you, especially about public safety issues now, in this atmosphere that we all live in. If we're watching TV when we're having dinner, we're in a horrible situation, at least in some areas of the state. And right now, going back and saying that, well, this person was considered a low risk because they had done their due diligence, they've been, they basically behaved for 10 years or whatever, and now we're going to take them off the list. I think the public is looking for no risk. They're looking for a no risk. Now that probably isn't ever going to happen. But the low risk thing means there's still a risk there. So I would just throw that comment out there. And I would also ask the sheriff, if I might, what kind of hindrance would this be, taking folks off the list? Now, I don't know how many we're talking here. I haven't been privy to every meeting, but when it comes to investigating you, it's good to know who's in your area when this happened, and if that list of offenders goes down, what kind of a problem would it have for law enforcement?
So is it okay to go to Sheriff Heck to answer that?
Thank you, Representative O'Neill. So looking at this specifically as a tool, so the registry is a tool, it's a list of people who have in the past committed a predatory offense. And that's the pool that I want to start looking at if I have a case that I need to solve. Logic would tell me if that pool is smaller, then I have fewer resources available to try to solve this crime. Now that shrinking of it may be eliminating a lot of people who are low risk and therefore didn't commit my crime anyway. But when you shrink it, there's a possibility that you are removing that person that lies in the weeds for 5 years and gets off the registry and then goes on to commit more crimes. I can't speak to how often that would happen. I don't know, but that's strictly looking at it logically. If you make that pool of names that I can look at as my kind of first line of suspects smaller, it's going to reduce the likelihood that I find that person potentially in that group. And as long as I'm jumping ahead of Representative O'Neill, if I could just touch on my experience with registrants who have missteps is that they aren't necessarily sent to court right away because, you know, maybe they bought a vehicle and it's got registered, or maybe they changed jobs and now it's 20 days since they changed jobs and they didn't quite get it reported in time. My experience in this agency and with our prosecutor has been that those people are not the ones that are getting brought into court for failure to register violations, that our agency and our prosecutor's office are looking for those folks who are obviously trying to escape their duty to register, that have moved and have been gone for 6 months and haven't told us, that are flagrantly thumbing their nose at the law and have no intention on complying. So at least in my experience here, these folks that might have small missteps, they're not the ones getting caught back up in the system. We work to correct those. It's not our goal to send more people into court and send more people to prison. It's our goal to get them in compliance as well.
Representative O'Neill.
Thank you. So thank you, Sheriff. That was really helpful too. When we started this conversation, I don't remember which subgroup it was, but I think the BCA laid out how many people are level 3, 2, 1, and then unassigned. And my memory is that there was a vast number, like 9,000 something, that were actually unassigned. And so when we talk about low risk, I've heard folks say, I think it was Renee maybe, that said, you know, we've come across people that the PO has said, well, they really don't belong on the registry. They don't need to be on it anymore. They're a lower risk. What are the thoughts of the group of starting with at least those that never even received a level, so they were not a 1, 2, or a 3, and start with the PO as sort of a point of reference to say, yep, just if we're going to do a process, and it sounds like administrative process might be something more helpful than the courts, but just a question out to the group. What are your thoughts about starting with that group, and then with the PO as being sort of the first person to sort of check a box or sign off on starting the process?
Sheriff Heck.
My question would be, does that group want that responsibility? And what training and what knowledge base are we relying upon that they have to make the proper determination as to who should or who should not be on that registry? I wouldn't want to be the one making that decision. I don't think I'm qualified to. And I think that we would want to really invest in making sure whoever is making that decision has the proper training, the proper tools, and is willing to take that on.
Jim.
To answer your question, Representative O'Neill, I think that would be a very good place to start. I think that meant much of, and I'm trying to be here in good faith. Much of what we're being presented against and trying to examine if there's any place for reform is that if you change this, you know, you're making things worse. I don't believe that's the case. I think that the folks as probation officers or people who have worked with these individuals know or have certainly more insight about what is going on. Is can we ever prevent anything risk-free? I mean, it's just the duality of life. But we always get into these situations where, you know, we have certainly a seriously bad thing happens, and then all of a sudden we come up with this incredibly draconian process that's reactionary. And what we're saying is that there's just a lot of people who could benefit from this and aren't a public safety risk. And I think we can explore this carefully and certainly provide, particularly for these people that aren't even classified. And I would even suggest that there's probably, I mean, there's a whole group of people on there that aren't even convicted of a sex offense. But they're sort of, it's like, well, there was an alleged sex offense, so we're, you know, you're on our radar. And as I said in yesterday's meeting, actually there's something un-American about this whole thing from a process standpoint. So by not even having a process to even get off seems wholly unfair. But I think we can do this.
Renee?
Yeah, what I heard being proposed was that the process begins with probation. So it wouldn't be probation that's making that decision, but probation could orchestrate that process with whatever the criteria might be. Of course, we always come back to capacity issues. What do they have the capacity to do? You know, I can speak to Hennepin County. And, well, there's a number of counties that have specialized units, so to say, that this is what they do. They know the clientele really, really well, and they know the cycle of behavior and the nature and all those kinds of things. So I could certainly, if the group would like me, I could go back and ask the probation groups, what are your thoughts about this? That might be really helpful here. I, years ago, as being a probation officer for those individuals, I would support, I mean, we're supporting clients transitioning back into the community successfully for a whole life, the whole well-being of their life. That is our intent. So I could certainly gather some information in that area. I would have done that as a probation officer. They do risk tools there. I've seen psychosexual evaluations come back after people have been in treatment, be it discharge, where they have reassessed their risk to reoffend sexually. So again, maybe that's where it begins and it gets orchestrated, perhaps. Again, I can go back if people would like to see what actual probation officers would think about that. So just an idea.
Representative O'Neill.
Thank you, Renee, for that. So yes, so I'm thinking that if you as an offender can't even convince, so to speak, your probation officer that you should be off of it, that the process should end there. That's the person that you have the most contact with. They supposedly should know you as far as your criminality and the better life choices that you're making. They're supposed to be holding you accountable to making positive social changes and all of those types of things. I'm just throwing this out as a point of discussion. Just, you know, I guess we hadn't even taken a poll yet and all of that, but I was just curious what the group might think. Maybe take it back to your larger groups, like Renee was saying, take it back to probations and just see. But my thought was, well, if you can't even convince your probations officer, then the process shouldn't even move forward from there because they should know you pretty well. But I see Sheriff Heck has got, you know, stuff to say too. That's good. And I'm not really on either side. I'm just trying to start a conversation about if we were to do this, we certainly don't want to put the public at greater risk. We want to make sure that this is, again, advancing public safety. And if people have stability in their lives and are stable and are sober and are making good life choices, those are all things that reduce the likelihood that they'll have criminal behavior. So that's the mindset that I'm coming from. So if you all would take it back to your groups that you're representing and just see kind of what they think. I know it's one thing for us to take a poll, but we're not just us. We represent groups of associations, or, with, like, Senator Ingebrigtsen and I are here on behalf of the legislature. So thank you.
Okay, Sheriff Heck.
I'll just add into the conversation the fact that some of the folks on the registry are not on probation. So there's that aspect to try to consider. And also, not to beat this dead horse again, but there is the resource issue, as Hennepin County has a unit devoted to people like these. You get into outstate Minnesota, and Benton County certainly doesn't have that kind of resource. And I doubt the farther out of the metro you go, that you'd see the likelihood of those probation offices having the type of capacity that Hennepin has, or some of the larger places.
Okay. I would like to clarify a couple things that I think some are getting a little bit mixed up, and even I refer to collateral consequences when in fact they're direct consequences. And I think Representative O'Neill, you were focusing on the specific definition of collateral, which means unintended, and the statutory ones are indeed, they're not truly collateral. They are intended consequences. And then residency restrictions or lack of housing, those would be the true definition of collateral that aren't directly included in the statute. So I think needed to clarify that a bit so we don't have a mistake on what we're talking about. Is there anything else?
No, if we are going to do a poll, just know that the BCA does not have an opinion on this. This would be a process that was, an assessment by other entities, and we would simply comply with whatever law was implemented. So we will not have an opinion on whatever poll goes through.
Is there interest in that poll right now? Yes. Here. Let's see. Let me just. Kendra, are you able to? We're just having a little bit of a technical difficulty here. Okay.
Yes, I'm interested in the poll. I'm interested in anything that could move us forward. I mean,
Okay.
we argue the same points in different committees. We need to know if we can move forward.
Representative O'Neill.
Thank you. I think it's important to know who's here and who they represent so that we understand what the poll is saying if we take one.
Okay, so I can just launch this simple poll. It doesn't, there's nothing scientific about it, but it has the two questions. No change to 10-year registration, yes or no, and no change to lifetime registration, yes or no. Is that appearing for everyone? tells you something, the wording of the question.
Yeah, I was just gonna say the wording, the wording caught me because I was gonna check yes for both of them. But obviously that's not where I'm coming from. So just like any standardized test, make sure you read the question really carefully. Well-drafted questions, it's just they're,
Yeah, this is just our first test of that polling.
Yeah.
Normally, we would want to not do it on the fly. But is everybody clear on what it says? Okay, I have 6 of 10. Not much of a number, but here's the result. Stacy, did you have a comment?
oh no, my comment was just on the questioning. I'm good, thank you.
So 6 responses, as you see. Renee.
So if I'm interpreting the poll correctly, we want to move forward for those individuals to look at that registration for that 10-year period, correct?
And correct, and then for lifetime, no. review.
Correct. Yep, yep.
Stacy.
So we haven't been talking about lifetime at all. I'd be curious to know, without anyone necessarily having to say how they voted, but I've been receiving emails as by virtue of being on this group from people who have been on the registry since they were kids and are lifetime registrants, who are law abiding and have the rest of their life to register. I am curious to know, just hear from people about their views on lifetime registrant and why someone who has been in compliance and doing well and has families and jobs and all that, if they can prove the same set of things, why a lifetime registrant wouldn't also be afforded an opportunity to petition for removal.
So just to clarify, the only way that you can become a lifetime registrant on the registry as a juvenile is committing murder.
Or multiple offenses.
Or multiple repeat offenses in which the years compile on top of them.
Yep, thank you. I know that.
Renee.
So this will be telling of how I voted. I'll just give that up right away. So as Olivia had said, typically it's some pretty egregious offenses or other things that gets an individual to a lifetime registry where I'm just not in my position right now. I'm just not willing to go there. I think whoever made the point previously, I think it's the timing of when you bring this forward. Starting with probation makes sense. Maybe a phase 2 might be that we look at those lifetime registrants when they registered as a juvenile. And then at what point, 25 years, I don't know what that looks like, we look at that. So again, the behavior is pretty egregious. They've been pretty non-compliant, or it's the offense itself that has created that. And so that's where I'm sitting anyway here today.
That's great. I'm just curious to know where people are at on that, just, substantively, like the why. So that's fine.
Sure.
Representative O'Neill.
Thank you. So in order for anything to change and be successful, the legislature, all the parties at the table have to come into an agreement that this is the correct path. And my concern is, my guess is from listening to the conversation and realizing that 2/3 said, yes, let's change, or at least give some sort of a relief or off ramp for those that are in the 10-year registry. But my guess is the law enforcement folks that are here are not in favor of that. And my caution would be to move forward very far until we hear literally from the Sheriff's Association, Chief of Police Association, some of the big groups. And I know Sheriff Heck is probably here on behalf of the sheriffs, and I don't know if they have taken a position specifically on creating this sort of off ramp of getting off the 10-year, but I just know that we're not going to be able to move anything forward unless we have, at the very basic beginning part of this, agreement. So I'd love to hear from Sheriff Heck and maybe even Senator Ingebretson, since he's a former sheriff.
Sheriff Heck.
So prior to the inception of this group, once I knew I was on the work group, but before the first meetings happened, I did send out an email that was circulated to the 87 sheriffs asking some general questions about this. And in the responses I got back, there was very little interest in those sheriffs in seeing changes made to the POR system. The few responses I did get back in favor of making changes would been along the line of the theme of make sure the right people are in there, that the people, some folks who have a low risk. There were a couple sheriffs that would support that. But that said, before I want to speak broadly for the Sheriff's Association, want to bring back some specific things that have now come up out of this group to get their reaction to these specific proposals. But in general, I right now don't see a lot of, I don't see broad support for changing the POR system in the MSA.
Senator Ingebretson.
Yeah, thank you for the opportunity. I'm certainly going to respect the polling from the sheriffs as well as the chiefs, and I think also the Josh from the BCA would be important to hear because they work with some pretty serious folks. But we're not talking about the serious ones, and I get that. I understand that. I know we're talking about the ones that I think Patty had referred to earlier as the one that, the girlfriend, boyfriend that made a mistake, and now we're going to have them registered the rest of their lives. That might be the ones that those few sheriffs are talking about that probably don't need to be on there. But whatever we do, we have to be very, very careful because the public is paying attention to this. And I've always said in my years that these crimes are even harder to get folks to admit to, especially when they're interfamiliar, than probably even armed robbery, even for that matter, murder. you know, not having to do with anything like this, but it just seems like it's tougher. And the general public, when you mention sex crimes, it just turns them off. They get just angry in their voice and their appearance, and so it's just that, you know, when you hear those concerns come from legislators and law enforcement, understand that there's there's certainly a tool there thing that law enforcement does need, because we don't want anybody running around doing this without being apprehended, obviously. And the general public in general, you know, they're very complacent. They don't pay a whole lot of attention. And if you're going to try and get something like reducing these things through the legislature, it's going to be a heavy lift. And if it's going to be something, it has to be something very light. And I'll just throw that out there for what it's worth. And I know some people aren't going to agree with that, but that's reality, at least where I've been for the last 15 years, it seems to me.
Representative O'Neill.
Thank you. I just thought it was important to hear, and I'm sure Sheriff Heck will do his due diligence and go back and talk to a few sheriffs, as I think we all should. I have a great sheriff here in Wright County who I talk to all the time, have cigars with him and all kinds of great things. So I think, not to derail all this, so I think what we maybe should talk about is the lowest level offender, kind of what Senator Ingebrigtsen had said, the ones that we all know they really shouldn't be on it, but there they are because of the rather rigid administrative process, and it probably needs to be rigid because it's one of those things that you want to make sure that you probably capture more than less. But I was curious, somebody had said that not all of these unassigned risk offenders that are on the POR have a probations officer. So I'm wondering, can anybody put some context to that? Like, who are we talking about? And I guess I'm trying to wrap my mind around who those offenders might be.
So depending upon their sentencing, depending upon the decisions made by the judges or the plea bargaining, et cetera, they may time out of having a probation officer. And so there are instances where somebody could be on the registry but not be considered under probation during that entire period of time. And so therefore wouldn't have a probation officer to report to, which is why we also have the provision for law enforcement when they're doing that registration data, because they may not have that regular check-in with a probation officer, if that makes sense.
5 years probation or something.
Yeah, so like, for example, somebody could have 5 years probation, but the default would be 10 for the registry.
Thank you. So they have successfully completed probation and been released from probation. So what if we start there? What if we start with the group that have been so successful that they've completed probation, they haven't had additional violations, they're 5 years out, but they haven't completed the 10-year. What if we start with that group of these very low risk folks and have a conversation there?
Jim.
I'm sure definitely for having that conversation. I acknowledge that there's probably, let's say someone is charged with a registrable offense. They pled out to a misdemeanor. They're going to be on probation for a misdemeanor. They may be off, but they still probably would have some relationship with a probation officer who might say, who might be able to at least, who could possibly weigh in, given that the person's in the community. There's just been no offenses. I mean, just because they don't have a probation officer doesn't mean they didn't have a probation officer at some point, that probation officer couldn't have some input.
Sheriff Heck.
And I have no problem with starting the conversation there. I just also want to point out the other possibility is that you have a person who did not successfully complete probation. They have actually executed their sentence. And the reason they're not on probation is because they served their entire sentence and now they've been discharged because they're no longer under the authority of the DOC. I'm not sure how that would play in with registration periods and all that stuff, but that's the other reason someone could be on the registry without a probation officer.
Thank you, Sheriff.
Did you have something else, Jim?
Yeah, but the fact that they had their sentence executed would probably mitigate against a probation officer from recommending discharge. Or, you
And they
know,
would also be assigned a risk level at that too, Jim, that would have
yeah, I
triggered
mean,
that
it
risk level.
just exponentially goes up. So I just don't.
Representative O'Neill.
Okay, thank you. Well, I feel like this is a more productive conversation. Thank you. So if we started saying an unassigned somewhat person that's completed probation and I don't know that they need to go back to their previous PO. I mean, I'm thinking through like a lot of people retire and stuff, so that may not be accessible. But at least if that was the kind of jumping off spot where they start their petition to whatever administrative process that we start, but that this process would only be amenable to them, would only be accessible to an unassigned person who has completed probation, successfully completed probation or something like that. Thoughts?
Sheriff Heck.
Just one question. What is it that differentiates between a person who is assigned a risk level and not assigned a risk level? Is that is that just whether they're put in custody and prison? What makes the difference between those two?
Yeah, a risk level is assigned to any person who is subject to registration when they are released from prison. And that's a prison in Minnesota, or it could be in a federal or other state jurisdiction, and they're planning on living in Minnesota. So those are the people who are subject to a risk level. They have to have gone to prison and have to have been subject to registration when they leave.
Okay, and so I'll defer
After
to the,
2007 and
Or 1997.
or 1997. And I think Representative O'Neill mentioned the 9,000 that are not risk leveled. So there's just going to be a variety of paths by which people go through this.
and so I'll defer to the folks that work more frequently with courts, but would it be possible for someone to have committed a felony level sex crime who would not go to prison? I'm not real clear on where the presumptive commits are. And if that's possible, then is that decision point between assigned a risk level and not assigned a risk level taking into account really what kind of risk level pool we're talking about?
So yes, we have seen that happen where people do not go to prison for those things. And therefore, I think your question gets at whether they would be risk assessed, and therefore, no, not necessarily.
Stacy.
Representative O'Neill, I do feel like this is we're headed in a more productive way. So I echo that. And to Sheriff Heck's really good question about, are there folks who have, done a felony CSC maybe, but that didn't go to prison, so they don't have a risk level. That I've seen that happen too. And which is why I favor, and I know this group probably won't go along with it, but I'll just say it for the record, I favor level ones being also given an opportunity to ramp off, because there's a lot of level ones that, I think if given the opportunity to, comply and, do the right things, can, show their PO, that, they can make the showing and deserve the chance to make that showing and have an opportunity to make their case. So I'll just say that for the record, this group can do with it what it wants.
Sheriff Eck?
So I want to make sure I understand this completely. Is there a process in the court system somewhere that then evaluates the potential risk level of these folks who have a felony but don't go to prison? Or are they just a great unknown? Or is it just that if they committed an egregious enough offense, they would go to prison?
I think Renee can answer that question.
Yep, I certainly can. So they're excuse me, assessed risk level at that point in time, but it's a different assessment. So what Olivia is talking about is that they're assessed a risk level upon release, and that's 1, 2, or 3. When we're doing pre-sentence investigations on individuals, a psychosexual is completed, and there's assessments that are completed, and there's a lot of factors that come into the behavior itself. How predatory was it, like stalking behavior? So there's a number of different things that come into consideration, and then it's assessing their amenability to probation. So could this possibly be a departure from a prison commitment because the individual is taking ownership, taking responsibility, and commonly they're not doing that in full by any means. But we know that if there's something there in that they're saying, yeah, I did something wrong, we can get them into treatment versus going to prison, because we know going to prison, sometimes they cannot get the treatment in prison that they're needed. They're going to be released, right? Eventually they're going to be released. So yeah, we're assessing on the front end to determine amenability to probation and where an individual is at. And if we're going to take them under supervision and recommend that departure, or perhaps it's not a prison commit, and we are saying, yeah, we'll work with this individual and get the individual into sex offender treatment. So I think it's being assessed at the front end for sure, because there are times when we will recommend a departure up, to be committed to prison based on the behavior at hand. And maybe an individual is super resistant to treatment and saying that they didn't do it and in full denial and not budging from that piece. So I hope that's helpful, Sheriff Peck.
Sheriff Eck?
Yeah, that's very helpful, very informative. So is it safe to say then, if a person went through that psychosexual eval and it came out saying, hey, this is not a person that's going to be amenable to treatment, that they would be more likely than to get a prison sentence?
Renee?
Yep, I'm coming. A couple of things. It depends. You get the prison system and you have the defense attorney and you have the county attorney, you've got probation. So all parties there are heard. I like to hope and think it depends on much, right? So, probation can come to the table and they can strongly advocate for an individual, but a judge can still say, and the victim has a voice right there too. So the judge could very well say, I'm not departing. So I think it depends on the whole dynamics of the court. Yeah, the court dynamics of who's present and who's speaking up. And again, I can only speak to my probation years. I would speak up and I would be very boisterous. I would be, if I really recommended, which is a difficult decision to make, that somebody should be committed, I would say that, this is a person that it's not by everything that's been lined out in a pre-sentence investigation and psychosexual, that I would not support that. Did I always get that? No, which is fine. Of course, we do our work then with the individual. So I think it depends who has strong voices at the table and where the judge is at.
Jim?
Practically speaking, I mean, from a practitioner standpoint, seeking a departure without a favorable psychosexual is it is highly improbable that you would get a departure, at least from my standpoint. I'm not saying it isn't possible, but I mean, it's just, and then couple that with the fact that now the relationship starts off with the PO, that the PO's recommended that the person go to prison. I mean, it's just not a recipe for success. When I talk to my clients about pleading to an offense, I talk to them in terms of, look at, one, let's not go in there and admit, do what's called a sort of an Alfred Goulet plea, which means you don't admit to anything. That's just setting them up for failure. I know that there's lawyers that do that, but I just don't think that's in the client's best interest. If they want a trial, they should have a trial. If you're talking about trying to program somebody, you have to put them in the position to be programmed from a defense attorney standpoint. There are going to be cases that, as Renee's brought up, that, that they fight, and it's possible that a judge put somebody on probation in light of a negative psychosexual, but it just, in my experience, it's not, I mean, that's like the linchpin of getting the departure. And if you don't have that, I mean, your chances are remote. And of course, all that information is going to be part of the recommendation as to whether or not the probation officer would recommend that that person be discharged or off the registry. So.
Any more discussion, questions? If I don't, oh, there you are. Sheriff Eck.
Probably gonna be that guy. Not to say that I'm for or against this idea, but I just want to point out that for all its failings right now, the administrative system, with its rigidity, has consistency in that it's spelled out in statute that if you do this, if this happens, this is gonna, you're going to register. When you start introducing a system like what's being suggested, there's going to be differences in how cases are treated, perhaps in Kittson County versus how cases are treated in Ramsey County. So again, I'm not saying that's a reason that shouldn't be talked about or shouldn't be embarked upon, but that is going to be an outcome when you remove the rigidity and the administrative function here.
Representative O'Neill.
Thanks. And I think no matter how we do the off ramp of the petition to be for relief, it's going to be different than how they get on it, just because we're looking at completely different things. The inputs of how you get on it are statutorily required. You've done X, Y, and Z, committed these offenses, where the petition to get off is much more subjective. You've completed treatment, or, to try to figure out someone's risk to society is incredibly difficult. And that's why I think we're all struggling in this, it's fairly easy to get on it. It's very hard to define what have you done or not done that qualifies you to now get a petition to get off of it. And so just by the way that this is structured, either way, the on and the off, we're going to be struggling. But I think that in this conversation, we've been trying to determine who are those that we all can agree that they're on it and they committed maybe like an age offense or something that was a consensual relationship, but it was outside of the parameters of statutory age. And, something like that. We can all look at instances where we know that there are people on it that shouldn't be on it, that are unrelated to being a predator. So it's parsing those things out. And I think the beginning of this conversation was, how do we at least start a pool of people that could qualify, whether they're unassigned or level 1, but that's only like barely to step 1, right? So then they have to convince either a probation officer or their former probation officer or something that they changed, that they have redeemed themselves, that they've made good life choices, that they are no longer the person that they were when they committed these crimes. But then it still has to go, obviously, to either a judicial or administrative process where they have to convince a panel or a judge that they have made these changes. And so I think the conversation today is, if we want to do something, we want to make sure that it's the lowest risk or no risk folks that have demonstrated good life changes and good behavior. So, again, I would encourage everybody to go back to their associations and kind of have these conversations. Maybe we don't want to do an off-ramp at all. I don't know. We could attack kind of at the other end of who the inputs, so maybe change some of the crimes or other situations that are putting people on the registry. But anyway, I appreciate the conversation today, and I really encourage everyone to go back to their associations and have deeper conversations of, because, I'm telling you, it can't go through the legislature unless we have buy-in in agreement, and we definitely need that from law enforcement and the BCA. I know you're not supposed to take a policy position, but your input is incredibly valuable.
Is that a good wrap up? We do still have a public comment period in case there are any members who are observing who would like to make public comments. Please raise your hand. Seeing none. Any last words from Olivia?
No, I'll get everybody the research as soon as I can. My suggestion to folks would be to not send items to the small groups, and I'm only realizing this now because there are people from all groups who will benefit from some of these conversations. So just know that that's going to be my practice. If folks have other things or they want us to send stuff, please send them to Mark and I, and we can distribute. We just want to be sure everybody's getting the same information.
And as of later today, it should be a quick process, as I said, to get these onto the web page now so that they're shared with all work group members. Stacy or Sheriff Heck, any parting comments? Okay. Oh, here we are. I was going to say Sheriff Ingebrigtsen, but Senator Ingebrigtsen.
Don't say that. Don't say that. I graduated
Yeah.
or failed from that, or I guess you'd say it. The BCA enforcement agency, I think they can participate, I think, and give the input. Can they not? I know Olivia's talked about, they want to stay as unbiased as possible, but they're working on some of the more serious cases where we could get their read on this as well as the sheriffs and chiefs.
Yes, I will try and get something. We typically try and avoid taking positions on things, as we just want to do what the legislature has directed us to do. But I will speak with Drew and others about getting a position on the off-ramp. And the position may very well be that we still have no position, but I will do what I can to get something for you guys.
Okay, so, oh, Representative O'Neill.
Thanks, sorry. So I'm wondering if Josh from the BCA has any thoughts. He has been so helpful in the previous groups and he's been real quiet this time.
Yeah, I don't have an opinion one way or another on whether someone gets a off ramp to the registry if they're been law abiding for a while. If you wanted to put something like that in place, I do have just. I think the one thing we have to be careful of is making sure that we're not minimizing some of the crimes that put them on there in the first place. And I know. So, I mean, sometimes when we say it's just an age crime, we have to be careful that it's not a 25-year-old with a 13-year-old kind of thing when we're talking about age crimes. So I want to just caution everybody to take a good look at what kind of what the criteria would be for people to be petitioning to get off.
Mark, may I?
Oh, there we are. Okay.
Thank you. And Josh, I might be the loudest voice at the legislature defending that 13-year-old. I literally wrote an entire bill called Hannah's Law, which became became the sexual assault working group that we rewrote the statutes. I certainly would never want to see that included. That's an absolute predator. That's like the definition of predator in my eyes. I was since we've rewritten it now 14 and under, or under 14 is now child. So we're talking about 14-year-olds and 15-year-olds with someone that's more than 36 months older is now the statutory definition. So I'm not talking about even more than 5 years old. I'm talking about a very narrow set of circumstances. Definitely not someone that's more than 10 years older. That's disgusting. And really the definition of predator. But when, obviously before we made these changes that went into effect on September 15th, there were some situations where it was 24 months older and some were 48 months older, and it was kind of all over the board. And it's something that we hear, oh, well, they were boyfriend, girlfriend, and they were just outside of the legal statutory limit on acceptable age of sexual relationships. So I am with you 100%, which is why I asked you to speak up, because you really do have so much firsthand knowledge of cases and how this impacts. And in my opinion, your expertise is incredibly valuable. So I am very grateful that you're a part of the process, because you do intense criminal investigations. So that's why I asked you to speak up. But just so you know, when I say something like that, it definitely is not even the 20-year-old and something, it's very, very narrow.
Yep, thanks, Senator O'Neill. I just want to make sure we're talking the same language there. Yeah, there's a small group in there where, yeah, that might make sense, but on wider scale, you still have to, I just want to be careful that if we're going to do something, you got to really narrow the parameters down so that we're encompassing the right people.
And we agree, Josh is awesome.
Anything else here? We will now wrap this up. Thank you all.